Kennedy. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. God Mayor, give your attendance and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
All right, good morning, everyone, and welcome to today's sitting of the Appeals Court. Happy New Year to everybody in the courtroom. 1 second, let me fix this. All right, the panel hearing your cases today consists of myself, Ariane Vuono, and to my right, Justice Rachel Hershfang, and to my left, Justice Gloria Tam. We have 6 cases on today. 2 of them are paired, and after the 4th case or so, we'll take a short break. I want to remind everybody in the courtroom that we've read everything that you've submitted to us, and so you should get right to your most salient points when you begin your argument. And also remind all of you that we have no rebuttal in the appeals court. That said, the first case is number 2023-0843, Commonwealth versus Thomas KEARNEY. And sir, I don't know if I'm pronouncing the defendant's last name correctly, so please feel free to let me know.
KEARNEY, thank you.
Okay.
And Happy New Year to everybody. Good morning. For the record, my name is Attorney Jack P. Milgram, and I represent the appellant Thomas KEARNEY. To my left is my co-counsel, Attorney Austin Birch.
Morning.
We have before the court today my client's appeal of a denial of a motion to suppress by the Boston Municipal Court Central Division. As this court no doubt is aware, the leading case in Commonwealth of Massachusetts pertaining to hotel searches is Commonwealth versus Molina, which is cited at 459 Mass. 819. It's a 2011 case and is still considered to be good law today. And as I'm sure this panel is aware, in Commonwealth versus Molina, there was a lively debate among the justices in regards to the issue of notice. Notice pertaining to defendant being told by hotel management that he no longer was wanted in the hotel, whether it had to be actual or it could be constructive. However, the single justice of the SJC, in allowing my client's petition for an interlocutory appeal, was of the opinion that Commonwealth versus Molina did not apply to the facts of this case because the single justice was of the opinion that the defendant in this case did not receive any notice whatsoever, whether it was actual or it was constructive. A survey of the law within or without the Commonwealth, state or federal, reveals that there are different methods that a hotel can use in giving notice to a defendant that is no longer wanted in the premises.
Can I ask you a question?
Yes.
When you say that there's no evidence of constructive notice in this case, what exactly are you referring to? In other words, your client was stopped in the lobby.
Correct.
Tells the officers that there's a firearm in his room.
Correct.
Right? So is your point that there was no notice given to him directly of the fact that firearms are not allowed in the hotel? Or was there no notice that he was, after he admitted that he had a firearm, that was basically an eviction, that basically he should have been aware of the fact that once he made that admission, that he would be evicted from the room?
Commonwealth takes a position repeatedly in their brief that when hotel management purportedly told the police that they didn't want to have the firearm in the hotel room, that terminated his stay in the hotel. But there are no cases, state or federal, within or without the Commonwealth, that supports that position. There are 4 methods that commonly are used by hotel management that have been recognized around the country. Number 1, if the defendant is directly told, you're no longer wanted in the hotel. However, the facts of the case are undisputed. He came down the elevator, he crossed the vestibule, he was stopped by the police, he spoke to the police went and spoke to management, and they went up to the room. But there is absolutely nothing to indicate at any time that the defendant himself was told by hotel management or the police that his stay was terminated prior to the police entering the room. That's one method. A second method a hotel could use is warnings. Somebody can check into the hotel, there could be problems, and management could go to the defendant and say, for example, there's noise complaints, or you're violating our policy in regards to parties. And if you don't stop we're going to ask you to leave, we're going to call the police. Again, the facts are undisputed in this case that there were no warnings to my client before the police entered the room, nor could there have been any warnings because management didn't know about the firearm prior to. A third method that is commonly used is a lockout. Before the police enter a room, if the room is locked out by hotel management, that's a method that's recognized by some jurisdictions. Some jurisdictions say a mere lockout is sufficient. Some jurisdictions say a mere lockout is not sufficient unless the defendant is aware that the lockout was by management as opposed to a defective key. But it doesn't matter in this situation because, again, the facts are undisputed that there was no lockout of the defendant from his room before it was entered by the police. A fourth method commonly used, and this was the method in Commonwealth versus Molina, the time when the defendant checks in, there can be a statement. If you violate hotel policies or local, state, or federal law, you can be asked to leave. In this case, the facts are undisputed. At the time that he checked in, there wasn't anything signed by my client. So we don't have any of these methods here in this case. It would appear that this case is governed by the decision of the Supreme Court of the United States in Stoner versus California, which is cited at 376 U.S. 483. It's a 1964 case, and it's still good law today. And the facts of the Stoner case are exactly the same on point as the facts here. In that case, police were aware that there was an individual in a hotel who had a firearm. The police went to the hotel, they spoke to management, and management said, by all means, go and take a look in the room, and they retrieved the firearm. And the case went all the way to the United States Supreme Court. The United States Supreme Court talked about the fact, the same as here, there was no consent by the defendant for a search. There was no notice to the defendant in that case that his stay in the hotel was over, and the Supreme Court said no. They said the motion to suppress should be allowed. It was a violation of the Fourth Amendment.
How do you
Exactly
square
what we
that
have
with
here.
the discussion in Molina, which, as you noted, is a lively one among the justices about the notice requirement? I'm looking at the majority opinion, and the majority wrote, because the hotel's policy permitted eviction without notice if the guest failed to comply with the hotel's rules and regulations, et cetera, the court doesn't say there because the defendant was aware that the hotel's policy permitted eviction without notice. You seem to be reading in a requirement that the defendant have seen the rules and regulations. Where do you get that part?
Well, if we look at Commonwealth versus Molina, and we look at page 821, where there's a discussion of the facts, there's a discussion about the fact that that he was given a statement to sign, where it says, this hotel is privately owned and the management reserves the right to lawfully refuse services to anyone. Guests must comply with all federal, state, and local laws, as well as the hotel's rules and regulations.
Yeah, no, I see that, and I
Right.
agree with you that that's part of the facts of Molina.
And he signed it. And in this case, he did not sign anything because there was no such document for him to sign.
So you
Which is a distinguishing
maintain that
factor.
the failure, that the absence in this record of any evidence that the defendant was on notice of this hotel policy means that he could not be evicted pursuant to that policy without being told?
That's correct. In addition, if we take a look at the record that was before the BMC, there was no evidence of what any policies would have been.
Well, there was, I'm sorry, there was testimony by the, about the conversation between the police officer and the desk clerk, in which the clerk told the officer that that was a hotel policy. So isn't that?
I agree to whatever weight there
Okay.
is to it. There was no written
Yeah.
policy that was introduced at any time.
Counsel, you just stated that your client never signed such a form,
In this
right?
case, that's correct.
That wasn't introduced, was that actually introduced in the record, or is it just a lack of any facts, one way or the other? Because then you just said, well, there's no form, there's no policy actually introduced with respect to a written policy.
And there was a pretty long evidentiary hearing in the BMC. Obviously, you were provided with a copy of the transcript.
Right,
And
but-
there was no evidence introduced by the Commonwealth, I think my brother would agree, as to any form.
Right.
Right.
So
Right, but you stated he never signed anything.
he never
was that
signed anything
actually-
because there was
right.
nothing for him to sign.
Right.
Okay. So, in any event, it's our position that Stoner versus California governs this case. Now, the Commonwealth also takes the position that in the event that there was a search in a constitutional sense, that the requirement of a warrant was not necessary here because of exigent circumstances. And we would argue that clearly is not the case. The police, in this case, what they could have done, in my humble opinion, should have done, is simply frozen the room. There isn't anything to indicate that they couldn't have done that and then applied for the warrant.
Well, so they know a couple of things at that point, right? They know there's a firearm in the room that is owned by someone who has said he does not have a license,
Correct?
and they know there's a guy in the room.
Correct.
So explain to me a little further why that warrants freezing rather than trying to retrieve the firearm.
I would distinguish from the cases cited by the Commonwealth. The Commonwealth cited several cases. They cited
Load hold.
They cited Commonwealth versus Moore, which is cited in Commonwealth versus Lupo. In Commonwealth versus Moore, there was a report of gunshots. So I would argue that the report of gunshots in that case makes it a little more of an emergency situation than in this case. In Commonwealth versus Lupo, the officers in that case were attempting to execute arrest warrants when they came upon a bullet, and as a result of bullets, and as a result of the ammunition, obviously there was a concern within that closed, confined space that there would be a firearm, and they searched. And of course, the SJC said that that was okay. And there was a third case, which was the BHA versus GUROLA. In that case, an exterminator had gone into the apartment unit and in plain view saw a firearm, and then subsequently a housing officer went in there. And that was upheld on appeal. However, in that case, in contrast, there was more than 10 officers that reported to the hotel in this case.
So you're saying the number of officers that responded to this case is what distinguishes it from that?
I think that distinguishes it from the Gorilla case, that you had 10 officers. I mean, they went upstairs. I understand what you're saying. Obviously, there was an individual in the room. They went up to the room and they neutralized that individual. I would argue at the point that that individual was neutralized, there's no longer any concern in regards to the firearm as long as the room is frozen.
Yeah.
I'm sorry?
I wouldn't say neutralized. I think that has a different meaning in this context.
Well, let's say that they took control of the
Secured him.
situation. You secured. That's fine. That's fine. So I would argue, under the circumstances, that's all that needed to be done.
Okay.
Unless there are any further questions, I think our argument's pretty clear.
Yep, I think that it is, I don't know if the answer is going to be clear, but the argument is clear, yes. Thank you very much. No further questions from the panel.
Thank you very much.
Good morning, Your Honors. May it please the Court, ADA David McGowan for the Commonwealth, asking this Court to affirm the order denying the defendant's motion to suppress. I differ from my brother in thinking that Molina controls here and not Stoner. Molina was expressly clear and can be easily applied to these facts. And one of the key languages that I found on page 827 of Molina is that the defendant could not have believed his right to use the hotel room could not be permanently curtailed by management if the hotel became aware of the guest's criminal offense in the room. The chronology of this case is the officers see what they see on Snapchat, think they identify the hotel room, they get to the front desk. They're interacting with the hotel. They learn the hotel does not permit firearms, legal or illegal, on the premises. The person they thought they saw on the Snapchat comes walking by them. They have a conversation with him. And on page 41 in the transcript is where this conversation goes. Sir, do you have anything you shouldn't in your room? Yes. Do you have a firearm? Yes. Do you have a license to carry? No. At that point in time, the majority opinion in Molina applies. The defendant has admitted after his Miranda warnings to illegal criminal activity in the hotel. He can no longer have an objectively reasonable expectation of privacy in the room.
Let me pause you for a minute there, because the language that you read from Molina comes after a discussion in Molina about the defendants having been notified by the hotel's registration card of the terms, which include no illegal activity on the premises. Two questions, or maybe more if I really get going. Am I right to understand, as your brother represented, that there is no evidence in this record one way or the other about any terms that the defendant agreed to in taking this hotel room?
That is correct.
And then two, how is it that, I guess, what is your best argument for the objective reasonable, the defendant's, this is a terrible question, I'm going to start over. What you said at the end there was the defendant could have no objectively reasonable expectation of privacy. I don't think Molina talks about, it does talk about that, but it talks about it in the context of the defendant's having an actual awareness of the policy. Why is it not relevant that the defendant have an actual awareness of the policy?
Well, I think twofold. In this case, for a moment, I'll circle back to it. I believe he does know the consequences of admitting criminal activity. That would be, I would argue he's subjectively in some trouble there of establishing an expectation of privacy, and objectively, after admitting criminal activity, to then think that he could reasonably maintain an expectation of privacy in the room following his admissions is separate. But here, Molina addressed the notice requirement in particular. On footnote 11, the legislature could have imposed a notice requirement on innkeepers, but notably did not. A little bit further in the footnote, there can also be no doubt that such a change would have an adverse effect on hotel or motel owners attempting to curtail the practice of using hotel rooms in connection with unlawful, in that case, drug activity. I think that applies here. There is no notice requirement for criminal activity. Now, it would be a different case if the premise for the constructive eviction here was it's a non-smoking room and they found cigarette butts during cleaning and then kicked them out and said anyone who wants to come into this room, including police officers, could. That's not this case. This is criminal activity that's established and admitted, and therefore, under Molina, as I read it, there is no longer an expectation of privacy that could be deemed reasonable, regardless of the defendant's subjective state of mind.
So from the moment you check into a hotel room, planning to use it to deal drugs, you have no reasonable expectation of privacy in that hotel room?
Yes. Well, such that a hotel can't terminate it as soon as they learn of it.
What was the termination here?
The hotel informs the Boston, in terms of the chronology here, hotel informs the Boston police officers of their policy, no guns, legal or not. The officers have a post-Miranda conversation with Mr. Kearney where he admits to having something he shouldn't have, that it's a firearm, and that it's an illegal firearm. At that point, the hotel brought they didn't say the magic words, we have now canceled the tenancy of this room, but the hotel now has learns of the admission that there's an illegal gun upstairs, that there's another person in that room, we're going to take you police officers right up.
So Mr. Kearney's act of admitting that he has an illegal gun in the room has the legal effect of evicting him from the room?
The hotel learning of it does. It's not a magic that there's a mission. In Molina, Mr. Molina didn't know that his room had been double locked. The officers sat across the hall for, I think, a number of hours, and I think they may even called it quits at one point.
They did.
The notice isn't... Notice of termination when there's criminal activity at play is not required as I'm reading the cases. Footnote 11 made clear the legislature did not require innkeepers to give notice, and for obvious reasons. In the quote that I started on 827, the next line beyond it, nor could he have believed that management could be stymied from the taking of action if the defendant could evade a run-in with hotel management. So that's that quote. So the SJC, as I understand it, is saying you can't escape this notice, either avoiding signing a form at check-in or dodging the hotel security or the clerk to be told, hey, now that we know that there's a gun, your room is forfeit. And that's how the SJC has given guidance, and applying that, I think, to me, clear language as far as case law goes to these facts, it's controlling.
So again, your position is that as soon as the hotel management learned of the gun, the suspicion, and that he admitted to the police officers post Miranda, it's at that point that the reasonable expectation of privacy is extinguished.
At that point, the hotel can permissibly bring the police officers right up. I think once it's admitted to be illegal, well, first a firearm, not these facts, but say it wasn't confirmed whether or not this individual had a license to carry, I would still be making these arguments that if there was a firearm in that room and the hotel says that's absolutely not our policy, I think the police would be able to go in there. I don't have those facts here. The facts are much stronger with the admission that he does not have a legal firearm. It's confirmed that it's an illegal firearm. At that point, the hotel does not have to say magic words to the defendant, does not have to give him a release form or some kind of stamp saying you're no longer welcome here. They can bring the police right up. And I think to hold otherwise, the touchdown of all our search and seizure cases is reasonableness. And that's what I think the SJC and Molina was struggling with, that longer sentence I repeated in the footnote itself, that to hold otherwise makes it really difficult to approach these potentially dangerous situations reasonably. And so each case is fact determinative, as this court knows, but following the chronology of how the police and the hotel management handled the situation, reasonable is exactly what happened.
Well, as you know, not everybody on the SJC at that time agreed, right? So there's a dissent in Molina that also, if that were the law, then of course your argument would be different.
I agree.
What do you think? Let me ask you a question. What do you think about the fact that that case is almost 15 years old now, and it's now been sent to us by the single justice? What is your 2 cents on that?
I think if Justice Botsford and Justice Duffley were sitting to the right and left of you all, that I think on these facts they would agree that objective reasonable expectation of privacy would not be established, as is the defendant's burden, principally because
of the admission.
Because of the admission right just outside the hotel with the police that can go then turn to the hotel. I think as I understood Justice Botsford's dissent, the issue and the concern from the court, which I don't think is unreasonable, and again, these cases are so fact determinative, that if there was cigarette butts, and that could be just enough. And while I'm not conceding that Molina, the majority would allow that, I haven't seen a case that has something kind of a technical violation. I think what Molina's holding was, and I see the dissent's concern, was non-criminal technical concerns eviscerating in a surprising manner that the general public wouldn't think would terminate their expectation of privacy willy-nilly, and that's the concern. What Molina, I think, doesn't go to that potential parade of horribles by expressly stating criminal activity. Those were the facts in Molina. Those are the facts here. And so I don't think the dissent would reverse this motion to suppress denial.
Okay.
And also, as Justice Hershfang, you noted that I also believe, separate and apart from the expectation of privacy, should this court find one against the Commonwealth, exigent circumstances require the police to do something here. This isn't just a home with one person inside. It's a hotel in a busy city in Copley. To leave a gun up there and freeze it when they know there's another person in there, in this case an Anthony, last name unknown, would be patently unreasonable and irresponsible in the police. So there's 2 justifications to affirm, but I don't think the defendant has met his burden in showing that he has an expectation of privacy that can be deemed both subjectively and objectively reasonable.
Was exigent circumstances was not argued in the trial court, was it?
No, it was not, but this court can affirm on any grounds, but I don't think it needs to get there. But if in the opinion wanted to mention it, that wouldn't be troublesome to the Commonwealth. If the panel has no further questions. Seeing none?
I don't, thank you.
Thank you.
I was just checking to see if the Commonwealth had argued that below. I thought my memory was different, but I think that you're correct. All right, thank you all very much. Take the case under advisement. All right, the next case is actually two cases paired together, and they're partially impounded. So it's Commonwealth versus ERICK Rivera and Commonwealth versus Ortiz, and the numbers are 2024-0214 and 2024-0211.
Good morning. May it please the court. Ian McLean on behalf of the Commonwealth.
Good morning. I'm just going to double check for a second and make sure, the housekeeping matter, you'll be arguing for the Commonwealth, obviously, and take your 15 minutes for both cases. And on the other side, we have just one person arguing for both defendants. Is that correct?
Yes.
Okay. I'll be in reserve. Okay, thank you very much. All right.
In shitting, so to speak.
And good morning again, and please continue.
Good morning, Your Honor. Ian McLean on behalf of the Commonwealth. Your Honor, this case presents a valid exit order and pat frisk. Here, the exit order was valid based on officer safety. Those officers had a reasonable apprehension of danger to themselves and to others, and the totality of the circumstances that were presented here in this case. And the subsequent frisk following the exit order was also valid based on their reasonable suspicion that these two defendants were armed and dangerous, again, based on the totality of the circumstances here. So turning to the totality of those circumstances, the situation they were presented with was responding to a shot spotter alert. When they saw the defendant's car, it was 7 to 8 minutes after the shot spotter alert had gone off. They then pulled behind the defendant's car, ran a CJIS inquiry, and then on the basis of that and the tinted windows that they had seen, they stopped the car. When they actually stopped the car, they were 3 blocks from the shot spotter alert, and it was 9 minutes after the alert had happened, as the motion judge found in the written memorandum and order. But the motion judge did note that that was approximate when the motion judge said 10 minutes and 3 blocks. If you read into the transcript, at pages 30 to 31 and 34, you can see that sort of chronology of when they actually saw the car and that they followed it briefly before they stopped it. So what we have is geographic and temporal proximity to shots fired here. Then we have the officers approaching the vehicle in the stop, and you see a furtive gesture on the part of the defendant. What the officer saw was the defendant leaning so far forward in the car that his head was essentially at the rear view mirror. The officer testified based on his training and experience that would have afforded the defendant an opportunity to either conceal something, which could have been a weapon, or retrieve something, which could have been a weapon. And officers are entitled to make those inferences based on their training and experience in this analysis.
Can I just ask a question about that
course.
fact? And actually, in the transcript, that Officer Stevens testifies that it looked as though the driver was trying to look back at the officers, right? And he says that he puts his face almost right up to the mirror.
Yes, Your Honor. That's at page 36 to 37, he says that. But I would also point you back to 13, transcript page 13, where he described what he saw, describing that his head was there forward. On 36 to 37, he said he also appeared to be looking at us in the mirror. But he was so far leaned forward that his head was essentially at the mirror. And in his training and experience, that afforded him an opportunity to reach down and conceal or retrieve something.
And I'm correct, am I right? That I looked at the videos. I know there are 3 separate videos that were introduced into evidence at the evidentiary hearing. And that lean forward, that gesture, was not captured on any of the body-worn camera footage. Am I correct?
That's correct, Your Honor.
Right,
Officer
okay.
Stevens' camera, as he approached the defendant, it clicked on and he already had the driver's license in his hand.
Right.
So there was a slight
It was
delay.
after, right.
Correct, Your
He
Honor.
turned it on after he saw the lean.
Yes, Your Honor. Transcript page 42, he indicates that he saw the person leaning as he was approaching the vehicle. So he's walking up, he sees this furtive gesture. And under both Stampley and under Torres-Pagan, this would qualify as a furtive gesture. So now we have a recent shot spotter alert, a furtive gesture as he approached the vehicle, and then through the collective knowledge doctrine, what the officers know about these two occupants.
What do you mean by a furtive gesture as he approached? Wasn't there a 6-minute delay?
No, Your Honor. As he initially approached the vehicle.
That was between that and the exit order?
At the beginning of the stop, as he approached the vehicle, that's when he observed the furtive gesture, the bending down and where he could have hidden or accessed a weapon.
The
Then he
driver's side window is halfway down when he approaches, right?
Correct, Your Honor.
Okay, all
Correct,
right.
Your Honor. And he makes that observation as he's approaching the vehicle. They have their initial interaction. The body worn comes on. He has the license in his hand, backs away from the vehicle. They run the CJIS inquiry. Additional officers arrive on the scene.
That's the 6-minute span.
Correct, Your Honor. Correct, Your Honor.
And why doesn't that 6 minutes serve to dissipate any fear of officer safety?
Well, Your Honor, the defendant could still have a weapon that he had reached down and retrieved and put underneath his thigh. The defendant could have still stashed a weapon in the side compartment in the door. The defendant could have still stashed a weapon underneath his seat. There's no reason why the mere passage of time would dissipate the concern for officer safety, particularly when we note that the concern for officer safety is not just at the initiation of the stop, but at the conclusion of the stop. When a defendant who has been exited of the vehicle is going to return to the vehicle, they could then access the thing that they had just stashed. So there's no reason why the passage of time would dissipate the concern of fear. And, Your Honor, if you wanted to say that it was some sort of, possible innocuous explanation, officers are not required to risk their lives on a possible ambiguity. And I'd point you to a series of cases for that, but Johnson is the most obvious case that talks about officers not being required to gamble on that objective ambiguity. So we have the shot spotter, we have the furtive gesture as they approach, and then through collective knowledge, we have what the officers know about these two passengers, two occupants of the vehicle. Both known gang members, the gang that they were in an active feud with another area gang, and the passenger of the vehicle having a prior firearm conviction and having recently been the victim of a shooting incident. So when you add all of those facts together, the totality of those facts, the officers were justified in issuing an exit order. They had a reasonable apprehension of danger, and they had a reasonable suspicion that these two defendants were armed and dangerous, which justifies the frisk.
I'm hoping you can clear up one thing on the record for me. During the body-worn camera video footage, it's possible to hear Mr. Ortiz talking with the officers about having recently been shot. But my understanding from reading the briefing was that the officers knew that he had recently been shot earlier than that. In other words, when they first identified that he was, who he is. Can you help me with when the officers first knew that Mr. Ortiz had recently been shot?
Was it clear from the record? It wasn't clear for me, and I guess that's what you're asking, when, not just when he was shot, because it was, as I agree with Justice Hershfang, in the video, it's as Mr. Ortiz, the passenger, is getting out of the car, you hear him say, oh yeah, I've been shot recently. And then he goes on to talk about it later while they're all standing there waiting, while the search of the car happens. My question, in addition to Justice Hershfang's, is at what point did the officers know, or is it even clear from the record? Because having read all the materials and reading the transcripts of the hearing and the videos, viewing them, it's not clear to me, maybe it just isn't clear from the record, at what point did the officers have that knowledge of the gang activity as you referred to, as well as knowing, looking at, I forget what exhibit number it is, and I know I'm sort of having several questions here. I'll stop and then I'll follow up later with my other question. So at what point, do we know from the record? Is it clear?
The record's not perfectly clear, Your Honor. But I point to transcript page 45. That's where Officer Stevens is talking about what they knew about the defendants. Officer Stevens recognized the driver as
from a previous interaction.
Yes, as he approached and interacted with him. And what Officer Stevens seems to be conveying from my read of the transcript is that his partner, who was approaching on the passenger side, recognized the passenger. After he had retrieved the driver's license from the driver, they back away a little bit, interact together, collective knowledge, they both know these two people and they know their history. Now, the fact that they discussed it after the exit order is additional extra, but they recognized the two people that were in the car that they were interacting with, so they already had that information.
At the time that they're walking up to the car, you think it's fair to infer?
Yes, Your Honor, at some point during the approach when they see in and can identify the two people, so prior to the exit order, basically.
But it's still not clear that they know that Mr. Ortiz has a prior conviction for a firearm, or that he had recently been, or maybe it wasn't even recent, that he had suffered a gunshot wound.
Well, I would disagree with that, Your Honor. The mere fact that they discussed it after the exit order with a series of officers.
You're saying
that
that's surplusage, that happened?
Correct, Your Honor. That'd be a better way to say it. That's surplusage.
Okay.
The information is from these two officers that conducted the stop and approached the vehicle, their knowledge of the two people in the car. So looking at it in the totality, we have a really recent shot spotter. We have the stop of this vehicle when the officer said they saw no other traffic on the road. The motion judge in her factual findings indicated that the road traffic was light. That's at Record Appendix 65. But the actual testimony from the officers was they didn't see any other cars on the road. That's transcript 34. And they were aware that no one had been arrested yet. No one had been taken into custody after the shot spotter alert. So we have a shot spotter alert. They're in the immediate area. They don't see any other cars. They see this car. There's a stop as they approach. There's the furtive gesture, which could have been hiding or concealing or accessing a
Well,
weapon.
I would actually like to address your attention for a moment, if I may, to the pat frisk of the car. Let's say, hypothetically, that we were persuaded that the officers had a reasonable fear of their safety for the exit order. Let's even say that the officers had a reasonable belief that the defendant was armed and dangerous, and for the pat frisk of the person. That would justify a limited scope of a pat frisk of the car, right? The way I look at it, the officer is looking inside the car for about a full 2 minutes. He's looking inside the driver's side of the car in terms of what the body cam shows, and then testifies that the firearms were seen only after there was a popping, if you will, or a dismantling of the console. How is that limited in scope? How does that fall within the scope of a legitimate pat frisk, even assuming hypothetically that an initial pat frisk was justified because the defendants were armed and dangerous?
Well, Your Honor, so I would disagree slightly with your characterization of how the frisk itself was conducted. The popping, I would slightly disagree with that. The testimony was that he observed scratch marks on the center console.
Yeah, and then he had to, that he could, nothing was in plain view. You'd agree with me on that? So it's not like Savello or those cases like that. There was no firearm in plain view.
Initially, correct, Your Honor.
Okay.
And then he took a different vantage point and used his flashlight and said he was able to see a gun. And then once they see a gun, now we have a search incident, and then they access the hide fully, and they can see a second gun.
Right, so that depends on a finding that I don't know if we can make, that a gun was seen with the flashlight without disturbing the, I'm going to call it a piece of plastic, sort of, of the console that he described as going from the console to the floor.
He
of the car.
removed, my reading of it was there's some kind of action taken, right? It wasn't that he looked underneath and saw it, but rather, because he testifies that, scratch marks indicate that, based on his training and experience, that this is a hide, right? That people often can hide firearms, for example, there, and that it's some kind of action was taken to doctor the area, right, to make it so that you could hide something there and that there was an actual removal, right? Wasn't, right.
Correct, Your Honor. Your Honor, I'd point you to the Daniel case, which is cited in the brief, that the limited frisk of the interior of the car is limited to an area where the suspect might gain possession of a weapon when he returns to the vehicle. That's the
Again,
point.
how do you gain possession of that? In other words, it took the officer a while to get the firearm out, right?
Well, yes, Your Honor, but he hadn't stashed it there, so he didn't know where to look. As the person who would be returning to the vehicle would know exactly where to look because they had stashed the weapon there. So the point of the frisk of a vehicle is to provide safety for the officers when
Sure.
the suspects are returned to the vehicle from any weapon they could grab when they return to the vehicle. This was a weapon he could easily grab when he returned to the vehicle. It was right in the center console.
Now, here's another question then. Does that require more findings of fact by the judge? If we were to agree with you and find that the area in this console area, okay, that appears that has to be, that some part of the console has to be opened up or somehow, I think the term used on the body cam was popped in some way, right? Do we need additional facts to determine whether or not you're correct, that was easily accessible to the driver, or can we proceed on what we have before us?
I don't believe you need additional facts, Your Honor. I think there's sufficient facts in the record right now, particularly with the combination of the body-worn video, from which you would make factual findings yourself, de novo.
Well, we
So-
can't make factual findings from a body-worn video. We can look at it, but we can't really make factual findings, especially if there's some dispute.
Sure.
You really can't see what's going on inside the car, but we're basically seeing the outside of the car and the police officer's, feet as he's inside looking. So That would be a little bit beyond our authority, I believe.
So you would look at factual findings the judge made de novo and determine whether you could use them or not
Right.
from the body worn, and the judge didn't really make significant factual findings from the body worn. I think there's enough to justify this as being a valid pat frisk that's limited in scope to an area where the defendant could access a weapon upon return to the vehicle. If you are unsure that there are enough factual findings on which to evaluate that question, then of course a remand would be on the table for that, to address that issue, with the instructions to the motion judge to make the necessary factual findings to resolve the question of the scope of the frisk.
Can I use part of your remaining time to just take one step back analytically and ask, as we all know that the showing that's required to conduct a frisk is not the same as the showing that's required to get someone out of the car. What is you think your best, most analogous case or cases on why it was reasonable to believe that these two defendants were armed and dangerous?
Well, so Your Honor, first I point you to the test, which is the totality of the circumstances. We don't evaluate any individual fact in isolation, we look at them all together. If you wanted analogous cases, Dyson, that's unpublished from this court in 2023, that was in the context of the shots fired.
Yeah, but in Dyson, there were additional factors, right? I mean, I was on that panel. So he gave inconsistent answers. There were things that heightened the officer's suspicion after the stop.
Well, then, Your Honor, I'd point you to Stampley and Sweeting Bailey. In Stampley, the stop occurred, all the occupants of the vehicle put their hands outside of the windows as the officers approached. There was not a basis for an exit order and frisk then. One of the occupants put his hands back in, reached down, and put his hands back out. That was enough to justify an exit order and a frisk.
There was a second, I thought in Stampley, though, there's more than one furtive gesture. He was told, he did that once, and I believe, am I not correct, that Stampley, he makes a second gesture, and that's when the exit order.
Your Honor, I see that my time has expired. May I respond?
Sure.
Thank you. Respectfully, I would disagree with that. My understanding of Stampley is it was a single incident of the passenger pulling his hands back in, ducking down with his hands, and then putting his hands back out, and that justified the officer's subsequent actions. Also, Sweeting Bailey, if you take out the one occupant of the vehicle acting in an erratic manner to try to distract them, and instead you replace that with the furtive gesture that we saw here, we have pretty much all of the same other facts that we're seeing in Sweeting Bailey. So that's an analogous case as well.
Well, I don't know if I would agree with that. It was Sweetie Bailey that individual was acting really erratically and different from prior times, but
Yes, Your
we
Honor,
can
that's why I say
examine
take
that.
that one out and put in its place the furtive gesture that we saw here, and then the other facts line up fairly similarly with Sweeting Bailey. But my time has expired.
Well, but don't leave yet, because
Yes,
we'll see
Of
if we have any further questions. Yes, absolutely.
So I just want to follow up on, or go back to the question that Judge Vuono asked about the 6 minutes, and you seem to say, well, there should be no weight given to that at all, right? And the 6 minute lapse that happened from the time the body-worn camera, went on, which was after the officer saw the lean, the gesture, right? And when they ordered them out of the car. And because in watching the video, in so many of these cases, again, they're so fact-specific, right, as we've talked about, and distinguishing some of the cases. So you're saying we should really give no weight at all, because the motion judge does mention that in her findings about the 6 minutes, right? That is a factor that she considers in her decision that lapsed, and it's unclear what information or what happened. And are you saying it doesn't matter? Nothing really has to happen. There doesn't have to be another gesture or some action taken or something else that happens for them to order them out of the car. Because so many of these cases, the language is that, the escalating situation happens very quickly, and, dangerous situations, and that we have to, consider that here. The video shows the driver and the passenger, they're sitting in the car. There's several officers standing outside. Everybody's sitting around waiting. They're cooperative. They're respectful. Nothing seems to have taken place in that 6 minutes. And so I guess your position is that shouldn't matter. It's irrelevant, right? Because of all the totality of these other circumstances.
That is correct, Your Honor. The duration of the stop could factor into a different challenge, whether they had unreasonably prolonged or extended the stop longer than necessary to achieve its purpose. That's a different challenge than what we're dealing with here. When we're dealing with the legitimacy of an exit order and a frisk, As the SJC instructed in Silva when viewing a traffic stop in hindsight, quote, "We think crucial to remember the answer to a police inquiry may be a bullet," close quote. And I'd also point you to Johnson that officers are not required to accept the risk of an ambiguity. And so that's what we're talking about here, is that there's no further actions. That's an ambiguity. They don't have to accept that risk. The risk that they're dealing with is that what they saw this person do was duck down and either conceal or access a weapon. That weapon could be underneath his thigh. He could have placed it in a place where he could easily access it upon returning to the vehicle. He could have placed it in a place where he could access it as the officers reapproached to return his driver's license. The risk was the same, regardless of whether there were a few minutes spent doing the CJIS check on his license and waiting for other officers to be there to provide support. The risk was the same. Thank you.
Thank you very much.
Morning, may it please the court. Edward Malloy for Mr. Rivera. It seems to me that there are 4 major points that the Commonwealth makes in its opposition, 3 of which are worth discussing here. They are the proximity to ShotSpotter, the furtive movements, the gang affiliation, which I don't think requires a lot of discussion, and then the subjective versus the objective standard at the end of the court's decision.
Can you do me a favor and just pull the mic a little? Thank you.
Thank you. With regard to the proximity to the ShotSpotter activation, the Commonwealth submits that the fact that these defendants were stopped within 10 minutes and 3 blocks should check the box of being within proximity to the ShotSpotter activation and support the exit order. That's not how the cases analyze the facts. The primary cases relied upon by the Commonwealth are Evelyn, Ford, and DePina, and in each of these cases, what the court considers isn't necessarily proximity, it's whether the proximity is in some way indicative of the fact that the people that were stopped were involved in the shooting. So in Ford, the court discussed the fact that there were multiple activations by ShotSpotter and that the police followed where those activations were. They described those as a specific linear trajectory and an acoustic trail of breadcrumbs. So what they're saying is that ShotSpotter activated 3 or 4 times, the police followed each of the activations, and when they get to the last one, they find the suspect who more or less meets what they're looking for. He's in the area where the last ShotSpotter activation is, and it's reasonable to conduct an investigation. In Evelyn, the defendant was stopped 13 minutes away from the ShotSpotter activation and half a mile away. It's not described in the case, but if you look at it on Google Maps, it's a 15-minute walk. They found him 13 minutes away. It's another case where there's a ShotSpotter activation. They find the person in a location that isn't just in proximity. It's in a place that is in proximity in a way that indicates they may have been the person responsible for it. At 7:04, the court says the time and location were consistent. The time and location were consistent with the theory that he had been present at the shooting and had walked to DeWitt Drive in the intervening minutes. And then the third case is DePina. In that case, again, the person was stopped 10 minutes after the activation, 3 blocks away. They met the description that was provided by the caller. That call was analyzed for veracity and reliability, and the court found that it met those conditions. And the court cited, I thought this was significant, at page 246, in DePina, the court cites 2 cases that go in opposite directions. And in one of those cases, well, in both of those cases, it's the connection to the shooting, not the mere proximity to the ShotSpotter activation that the court analyzes. So the dispute in this case comes down to the fact that the judge hearing the motion said that where they located the defendants and when they located them there was not indicative of them having been involved in the shooting, because it's not that the court wouldn't assume that people would wait around at the location of the shooting while the police were responding. That's really a factual question, but that's really what this dispute comes down to, is that the trial court looked at the circumstances of the case and determined, based on the facts, that the proximity itself didn't establish a strong connection to the shooting, and the Commonwealth submits that those additional circumstances shouldn't be taken into account, that the court should simply look at the proximity and say it checks the box and move on. I submit that that is not consistent with the indication that the trial court needs to analyze each of these cases on the specific facts, and that the factual determinations by the trial court are entitled to deference.
But
Well,
isn't it
okay.
part, I mean, as we've been discussing here today already, the analysis that we're doing here is a mosaic analysis, right? We're not looking at individual factors and asking, is this enough, is this enough, is this enough? And I hear you that you're saying that the proximity, the temporal and physical proximity to the shot spotter activation here is not as tightly connected to the stop as it is in some of those other cases. Where I lose you a little bit, and maybe you're not saying this, is that the corollary to that is, so the temporal and proximity and spatial proximity is not part of the calculus.
Right.
I mean, it's weaker, to
Right.
be sure, but it's not nothing.
That's exactly right. And that's a theme that carries on through each of these issues, is that in none of these issues did the court say that it was completely discounting it. The court simply said that it was entitled to less weight or it was less probative. And at no point does the trial court say that it was discounting the proximity to the shot spotter activation. It just says that in these circumstances it didn't provide very much probative value. The same is true, and I'll move to the second issue, the furtive movements. I think that the issue that the Commonwealth raises with furtive movements is addressed most directly by comparing Note 3 of the Commonwealth's brief with Commonwealth versus Goey and Stampley. In Note 3, the Commonwealth acknowledges that the court, as you noted, Justice Hershfang, doesn't actually discount it. And in Note 3, it says that the court never found that the officer's safety concerns were unreasonable. So I think that compares with Stampley, because in that case, the trial court basically found that there was reason for the exit order, and then found that something happened or didn't, that as time went by, it dissipated, and that there was no longer a reason for the exit order. Stampley's maybe as close as the cases get to saying that once there's a reason for the exit order, the change in things or the delay in time doesn't make that dissipate, that once you have it and it doesn't go away. I'm not sure that that's what the law actually is, but even if you take that as black letter law, that isn't what happened in this case. And that actually goes to a question that was raised earlier with regard to Stampley. I believe that was Justice Tam was asking whether there was one or two furtive movements. In that case, there were two. And I think the sequence goes to this point. If the court in Stampley had found that there was definitely a reason for the exit order after the first furtive movement, and then went on to question whether there was still reason for the exit order after we get to the second one, then it would conflict with Goey, but it doesn't. What the court in Stampley is saying, that once you get to the point where you say there is enough for the exit order, which in Stampley happened after the second furtive movement, then dissipation isn't a thing. In this case, the trial court never said that there was a cause for the exit order based on the furtive movements. If it did, then the Commonwealth would have a better point about it being inconsistent with Stampley and Goey. But the court was in the process of deciding whether the furtive movements would support an exit order when it got to the discussion about the 6-minute delay. And what the court did was it combined the exit order on the one hand with the 6-minute delay on the other, and balanced the two to decide whether together they would establish a cause for the exit order, and concluded that it didn't. So, and it also considered the fact that the defendants appeared cooperative. So I think the answer to the Commonwealth's issue about the furtive movements is that the trial court never actually said that there was cause, and that its consideration of the 6 minutes wasn't to dissipate cause for the exit order. It was to decide whether there was cause in the first place, and decided that it wasn't. The third issue raised by the Commonwealth is the gang affiliation. I don't think that requires very much discussion. The trial court indicated this was undifferentiated information that wasn't connected to the reasons for the stop. And for that reason, it didn't carry very much weight, and the court didn't discount it, just that it didn't carry very much weight. And then the last issue that the Commonwealth raises, that I think is worth discussing, is whether the court was applying an objective versus a subjective standard. There is a line at the end of the opinion that says that the trial court perceived that the police were acting on a hunch. That line does not indicate that the trial court is applying a subjective standard. All the trial court is doing is having completed its analysis and concluding that on an objective standard there wasn't a cause for the exit order, acknowledging the officer's good faith. It's a line that simply says that the court understands that the officers were acting on good faith, hunch, and trying to do their jobs, but it does not say that because of that fact the court is deciding there wasn't cause for the exit order. The court has already reached its decision. It's just a line at the end that acknowledges the officer's good faith. I can move on to some of the other questions.
No, I just want to back you up for a moment with respect to your point about the gang affiliation.
Yes.
And of course, in many cases, that's a factor that is significant, like Sweetie Bailey, for example. We will, of course, defer to findings of fact, which is what people knew at the time, what was the gang affiliation, the exhibits that were introduced to the judge. But we, of course, are free to give that more weight if we want to in the calculus, correct?
Correct.
All right.
The fact that the defendants were known to be affiliated with gangs is not irrelevant, and the trial court didn't treat it as irrelevant.
No, I understand that.
Right.
Yeah. Let me ask you another question while I have your
Yes.
attention. The same question that I asked your brother, and that is, what if we were to disagree with the judge and find that there is a sufficient basis for the exit order and for a initial pat frisk of the person and a limited pat frisk of the car? Do you think that there's, hypothetically, and now we're going to address whether or not the pat frisk of the car was sufficiently limited in scope or not. Do you think that we can do that on this record on our own, or that would require a remand?
So it's whether there's a factual dispute, and it seems that the factual dispute in this case would be the degree to which the officer manipulated the vehicle. I'd point the court to the transcript of page 22. He indicates that he pulled at the plastic casing. He also says that he shined a flashlight up underneath, and I suppose I acknowledge that the record is not clear about what that means, shining the flashlight up through the case. So my position would be that there is a factual dispute about the degree to which the plastic was manipulated, and that would require a remand.
Okay.
I would also note that the court cites Exhibit 6 at 8 minutes and 25 seconds on that particular point, but as was noted earlier, the video doesn't actually show the manipulation inside the vehicle, so I think there's still a factual dispute. If the court doesn't have any further questions.
One moment, I'll check with the panel. Nothing here? No further questions. Thank you both very much. We'll take the case under advisement. Right. We'll now go to our next case. Our first civil case, and this case also is partially impounded, Wells Fargo Bank versus Benjamin KOULSEY. I don't know if I'm pronouncing that name correctly. And another, and case number is 2024-0255. So I understand that Sarah KOULSEY is going to be arguing today? Yes, Your Honor. And am I pronouncing your name correctly? It's KOULSEY. KOULSEY. Okay, no, we do our best to be respectful in that matter. So, okay, Ms. KOULSEY. Yes, good morning.
Good morning, Your Honors. If it pleases the court, I'm Sarah KOULSEY, pro se appellant, representing myself and my co-appellant Benjamin KOULSEY. On January 30th of 2007, I and I alone signed a mortgage loan and note with Option 1 Mortgage Corporation. On or about October 14th of 2008, American Home Mortgage, as a successor in interest to Option 1, assigned the mortgage to Wells Fargo trustee. This assignment is not just voidable, but void. This assignment was created by a company called DocX. DocX used the signature Linda Green to sign over 1 million mortgage assignments through all sorts of different banks. These assignments were made through the 2007 and 2008 housing crisis. Linda Green is a fictional person. She has never been a party to any mortgage, no CEO, nothing. Linda Green, as I said, is fictional, and the owner of DocX is a woman named Lorraine Brown. Just a couple of years ago, Lorraine Brown was sentenced to 5 years in federal prison because of this massive scheme that they had created with the fake endorsements on the assignments.
I'm just going to stop you for a moment and remind you, because you are pro se, that we, of course, only look at facts that are in the record.
It should be in the record, Your Honor, yes.
Yeah, just wanted to let you know that.
Yep.
And also, let me ask you this. Is it true, or do you disagree with the fact that the issue that you're raising right now, whether or not the foreclosure is void or voidable, has been addressed by
It
other
has
courts?
not been addressed, Your Honor.
All right, so now, of course, you know that counsel disagrees with you on that.
I'm sorry?
You know that counsel disagrees with
They
you
do,
on
yes.
that. So if you could explain your position on that a
course.
little more fully.
In 2015, I had sued the loan servicers. The loan servicers at the time were Option 1, American Home, Homeward, Ocwen. And when the case initially went to the Superior Court, I had not included Wells Fargo. At the time, there was an allonge to a note that said Wells Fargo Bank N.A. was the one who owned the note to the property. When the judge of that case had questioned the fact that I hadn't included Wells Fargo, I amended my complaint for the first time and in name only included Wells Fargo Bank N.A. They were listed as the supposed note holder of the mortgage. In 2015, the case was before Judge Robertson for quite a while. She had agreed with me that there were most definitely Chapter 93A claims in regards to Option 1 and the practices with the mortgage and how they had broken the forbearance agreement and they had broken the mortgage itself, the contract. The case was given back to me to file a second amended complaint. I filed the second amended complaint, and in that amended complaint, I had added claims specifically in regards to Wells Fargo Bank as trustee not holding the allonge to the note. When the case was brought back, Judge Robertson recused herself, and we were given Judge Mastriani. Judge Mastriani, even though I had asked multiple times for oral hearings and to have a third amended complaint, I was denied, and to this day, I've never actually seen the man in person. He ruled solely on the papers and did not adjudicate any of my claims in regards to Wells Fargo Bank trustee.
Well, when you say he didn't adjudicate, by ruling on the motion, why did that not encompass all of your claims?
Because specifically the claims in regards to 93A, the primary claim on the 93A was the fact that Wells Fargo trustee did not hold the allonge to note. And in this state, in order to foreclose on a property, you have to hold not only the mortgage loan, but the note as well. And because Wells Fargo trustee had supposedly the mortgage loan in their possession, but did not have the note, they were not, as far as I was under the assumption, allowed to foreclose on the property. Judge Mastriani, in his ruling, and I've read through it with a fine-tooth comb, it was included in one of my appendixes.
short.
Not once does he mention anything in regards to the fact that the allonge to the note did not have Wells Fargo trustee listed on it.
And so I repeat my question, and
Yes,
not to
apologize.
belabor the moment, but this protracted case, very complicated.
Yes, it is.
You clearly have a very good understanding of every aspect of it. Although the judge did not directly address this issue, why isn't it that we, as in our position as the appeals court, why do we not assume that that was adjudicated, even though it was not written in his order?
Your Honors, it's primarily the crux of the issue when it comes to who owns the mortgage. If I signed a document under my maiden name, it's not a legally binding document. I have been COULSEY for 22 years. So if I was to sign at Sarah Mansfield, it would not hold up in court. When it comes to the Wells Fargo allonge to note, if it's not in the trustee's name, it should not be allowed to be used in a foreclosure proceeding. And I'm not exactly sure why Judge Mastriani did not specifically rule on that claim. In all honesty, if you read through his, I apologize, I'm losing my train of thought, his
order.
His order,
Yeah.
thank you, Your Honor. If you read through his order, Wells Fargo is not mentioned very much at all. The original case in 2015 was brought in order to try to get the loan servicers to work with me in order to pay my mortgage. That's been the whole thing since day one. I never asked for money or compensation or my home for free.
Right.
I just want to pay my mortgage like everybody else. So apologize, I'm
That's
trying
all
not to
right,
get
that's
emotional.
right, take your time.
So the fact that anything in regards to Wells Fargo was not adjudicated, it was mostly for the loan servicers and how they treated me, and how, under those circumstances, the statute of limitations for all of my claims had long passed.
Sure, I certainly understand the thrust of your complaint and your argument, which is well pleaded. And I pause on this issue only so that you understand that upon occasion legally judges don't mention every single thing in their orders or in their decisions, and that doesn't always mean it's been ignored. It just may be. I wouldn't call any of my colleagues sloppy. That would not be appropriate. But sometimes things don't always get all the I's don't get dotted and T's across. So that's why I bring it up.
No, and Your Honor, I completely understand that, but the crux was that even though I had asked for oral arguments, and as you all know, I am a pro se litigant. I am not an attorney, although due to all of this, I have gone back to college and am studying law as we speak. But
Bad idea.
thank you. But because the whole Wells Fargo issue was the crux of the case, I had asked for oral arguments so that I could speak before the judge. I can do the papers, but I feel more comfortable speaking before the judge to plead my case. I was not granted that. And I try not to ask for too much leeway being a pro se litigant, but under those circumstances, and never having been before that specific judge personally, I felt that it was warranted to be able to argue my case in front of him. And then when it came to the complaints itself, as I had stated, the first complaint, I only amended it to literally put Wells Fargo's name on it. So the second amended complaint was initially my first amended complaint. I was not granted the opportunity to do a third where it would have been.
I'm going to jump ahead now a little bit too, if I may. And that is what's before us today. I mean, that's of course the history of the case.
Yes,
right?
yes.
Is two rulings, as I understand it. The ruling on your on the motion for summary judgment, and also the same judge of the housing court who actually allowed a motion to dismiss some. So I would presume that you did have the opportunity to make an oral presentation with respect to those motions.
With the housing court, yes, Your Honor, yes.
All right. And those are really the two issues that are before us. The rest, of course, come into play. But so why don't we concentrate a little bit on those two orders?
If I may say that the judge in the housing court, Judge Kane, primarily ruled based on re judicata, stating that all of my claims and counterclaims in the housing court matter had already been adjudicated in the 2015 matter. And as I stand before you again, I
Disagree with
contest that and say that my claims were not all adjudicated, so re judicata should not have applied in my regards. In my husband's regards, he was not a litigant in either the 2015 matter or when I attempted again in 2021. He is not a party to the mortgage where he did not sign it. But if you look at the original mortgage document contract, it states my name as Sarah COULSEY, and immediately after it, it states married. When I went to the closing on the property before the lawyers for option one, my husband was with me. We have been married for 22 years. So the entire time that we have lived in the home, he has been a party to the home. If I am reading this correctly, the mortgage contract, by putting that I was married, in essence, lists him as a third-party beneficiary. And in 2019, I filed a homestead exemption homestead declaration in the land court, including my husband's name, which to me reaffirmed that he is a third-party beneficiary to the contract. When the appellee brought forth the housing court matter, they brought my husband into the mix as well, which again enforces the fact that he would be a third-party beneficiary. As a third-party beneficiary, my husband is due his day before the court. And Judge Kane in the housing court immediately ruled re judicata against my husband based on the prior litigation that he was not a party to.
But of course, we have this theory of law, we'll talk about privity, which is what has been explained. And, the purpose of that is so we don't repeat another 7 years of litigation with a different party if that party stood, and there's 3 or 4 factors to consider, but let's say sort of stood in the same shoes. Let's just say it that way. Why isn't that the case here? Just why doesn't he stand in the same shoes as
Again,
as
it
you
goes
did?
back to the fact that my original case in 2015, when it came to who exactly owns the mortgage note, was never adjudicated. Wells Fargo, they can claim they own it all they want, but if you look at the evidence that I have submitted, not only in the housing court, but in the original case in 2015, it shows that the original assignment from American Home Mortgage, who was successor in interest to option one, that document was void. It is a fraudulent document. The next assignment of mortgage, which was a confirmatory assignment, was from Sand Canyon, who is what option one is now known as, to Wells Fargo. That assignment is also void because at the time, Sand Canyon did not have in their possession any mortgage loans or notes. They admitted it on the record in a bankruptcy court case that I have in my brief. To not rule on the fact that Wells Fargo has not shown, beyond a shadow of the doubt, that they hold not only the original mortgage documents signed by myself, which I have my own copies of, and that they do not hold legally the note, the ink-signed note in their possession, I don't see how any court could grant them the rights to foreclose on my property.
So, let me ask an obvious question. Who does have the right, in your view?
That's a good question. In all honesty, I would have to say option one. They were the only other original party to the contract, and because the assignment of mortgage from American Home, who was their successor in interest, is not a valid assignment, that completely negates any and all chain of assignments after that. So I would have to say option one. And if option one came forward today and said, we're willing to work with you, start paying, I would be more than willing to start paying. And at any point throughout these last 17 years, if Wells Fargo had even given me the option, I would have been paying them all along. I'm not trying to get my house for free. I want to pay my mortgage. I don't want to lose my home, a home that my children have never known any other. It's a home that my husband and I have done extensive rehab to. We have lived in and worked on most of our married life. I can't relinquish my home in regards to a bank that is using fraudulent documents in order to steal my home. And this is not their first attempt at this. If you look at my reply brief, I listed multiple different lawsuits between the attorney generals of every single state in this country going after Wells Fargo Bank for these exact same practices. But sadly, it seems like in the court system, when it's a pro se litigant, we don't get the same justice as the attorney generals do when it comes to going after the banks.
Okay, all right. Well, I see your time is up. I'm just going to check with the, I don't see any additional questions. Thank you for answering all my questions.
Much
I
honored.
appreciate
greatly
it.
appreciate your
All
time.
right. Okay.
Thank
Thank you
you.
both, and now we'll hear from Counsel for Wells Fargo. Good morning.
Good morning. May it please the court, Stephanie Sprague for the appellee, Wells Fargo Bank as trustee. So this case is obviously it's an eviction case. My client has the burden of proof in the eviction case to show that we are entitled to possession. Our prima facie case is set forth by this court in the SJC is to produce the foreclosure deed and affidavit of sale, attesting that we have complied with the terms of the mortgage and the statutes relating to the mortgage. We had done that in our initial filings and our motion for summary judgment. The opposition to the motion for summary judgment actually did not have any affidavit submitted with it that attested to any of the facts. It included documents, but none of those were properly submitted to the court. So in the end, essentially our motion for a summary judgment, the facts, none of those were rebutted. The counterclaims and defenses had all been previously precluded by the court, and that's where the res judicata argument comes in. So you can read my brief on that, but I will address some of Your Honor's points that you made to Mrs. COULSEY. Her husband is, I would say, in the utmost privity with Mrs. COULSEY. He was never on the deed, the mortgage, the note. However, they are married. He is a resident of the property. I'm not aware of any cases, any statutes that would claim that because someone is identified as a married person on a mortgage, that their spouse is automatically a third-party beneficiary of the mortgage itself. But he certainly is in the utmost privity with her, and she has the the incentive to fully litigate her claims regarding the mortgage, regarding the note, regarding her treatment by the banks, and she has utmost. She has certainly litigated those to the full extent that she could.
Let me ask you a question that I'm sure won't surprise you. But of course, the case is coming to us new as a protracted history.
Yes.
I have to imagine that there have been numerous attempts at resolving this case.
Yes.
I'm looking for some reassurance that is the case, that there has been some movement on the part of your client to resolve the case.
Yes, Your Honor. I'm surprised to hear Ms. COULSEY say that she's never been given the opportunity to pay her mortgage. Every notice of default, every notice to cure is an option to start paying her mortgage again to cure the default. There are under 35B, we send out those applications to apply for a loan modification. She admits many of her facts. She applied for loan modifications that were not granted. I believe I myself actually sent her or offer to look at a loan modification, whether she wanted to apply for one. Nothing was applied for. That was, I believe, in the 2019 period when we were going through the appeal process in the First Circuit. So yes, there certainly have been attempts throughout the years from the original 2008, certainly through 2019, and then in 2020 she got the 35B application. So yes, there have been many attempts to try to resolve this over the years. My clients don't revel in foreclosing. They would rather have a performing mortgage. They would rather people pay their mortgage and get on a schedule. This certainly isn't their first option, as you can see by the timeline alone. Payment hadn't been made since 2008, and the foreclosure did not occur until 2021. This is not something my client is trying to quickly foreclose on. They do attempt to do all options before getting to that.
All right.
And regarding the whether the prior claim on the note had been actually adjudicated, I would agree, even if it wasn't in the decision. The issue was certainly out there. In the 2015 case, there was the final decision was a judgment on the motion on the pleadings. The opposition to that judgment on the motion on the pleadings filed by Mrs. COULSEY was primarily regarding ownership of the note and Wells Fargo's standing in order to foreclose. All of these cases had to have at least considered Wells Fargo's standing to foreclose, especially because there were requests for injunctions. In 2015, there was a request for an injunction, and in 2021, there was a request for an injunction to stop the foreclosure that was proceeding the next day, and the court did hold oral argument on that in Franklin Superior Court, and they found the same day that res judicata did apply, and they did not stop the foreclosure that was scheduled thereafter. So in order to make that decision, they had to decide that Wells Fargo did have standing as the note holder and as the mortgagee to move forward with the foreclosure. But beyond the res judicata arguments, which I think the court could end there, end the decision there if you felt appropriate, on the merits, we would still win this case, even if this was the first time this case was being brought. Wells Fargo, as trustee, is the note holder. The note itself is in evidence with multiple affidavits before and after the foreclosure that are recorded in the registry of deeds stating that Wells Fargo, as trustee, does hold the note. It is made out specifically to Wells Fargo, as trustee. They hold the original note. Part of Mrs. Coulsey's argument is that the original note was never provided to her, but of course, banks do not provide the original note. We have to hold the original note and be in possession of it in order to foreclose. So we do not send them to the borrowers. We need to keep them. We do send copies, and copies were sent. She did receive those, and she admits in her pleadings that she did receive those copies. The assignment of mortgage
So
is...
you're saying that the crux of it is the, I'm going to use these terms just as a description, the refusal to acknowledge that Wells Fargo does in fact hold the note and the mortgage, is really sort of the linchpin of this as far as you're concerned.
Yes, Your Honor.
Right. And your point is that judges have already decided that they do.
Yes.
You've met your burden of showing it, even though you haven't produced an original, because you wouldn't do that. You would, all right.
Yes.
So there's not some, as far as you're concerned, not some nefarious, empty box, that the note is just, there's no note. It's actually there and you have copies of it, is your point.
Yes, Your Honor. And in order to complete these affidavits, the 35...
Under penalties of perjury, exactly.
Yes, yes. So my client does look through. They find the original note. They say, do we have it? Yes, we do. Now we'll sign the affidavit. And they do that prior to the foreclosure, and they do that after the foreclosure. And both of those are recorded in the registry of deeds. Those were submitted to the lower court as evidence, and there is no evidence on the other side to oppose summary judgment to say that my client does not, in fact, hold the original note. Part of the argument, I believe, is that Sand Canyon wouldn't be able to assign the mortgage because they didn't hold the note, but that issue has been decided by this court in the SJC several times. There is no requirement to own the note or hold the note at the time you assign the mortgage. The two documents can be split. They often are split. They just need to be reunited before the notice of sale is sent. That wasn't until, but the second foreclosure was scheduled until 2021. At that time, they had been reunited. So even if, and I'm not admitting to it, but even if my client did not hold the note or did not own the note at the time the assignment of mortgage was signed, it's irrelevant, essentially. Regarding the two assignments of mortgage, the first one that was signed by, it was actually signed by a loan servicer, ASMI. And then there was a confirmatory assignment of mortgage. The reason for the confirmatory assignment of mortgage is ASMI is a loan servicer. Mrs. Coulsey complains that there was no assignment from option one to ASMI, but the way that assignment of mortgage was executed was ASMI as successor in interest to option one. So there wouldn't be an assignment to ASMI from option one because they were signing it as the successor.
As the same entity.
To option one. They were the servicer, probably should have read attorney in fact, not successor in interest, because the successor in interest via name change was Sand Canyon, and that is why there was a confirmatory mortgage, assignment of mortgage signed by Sand Canyon, because they are option one. It was a name change, seamless, just turned from option one into Sand Canyon. They're the ones who signed the assignment of mortgage. It was done by an assistant secretary. That was not done by this Linda Green person she mentioned.
Sand Canyon's assignment to the mortgage to your client, when exactly did that occur? What year was that?
I believe that was in 2011.
Okay.
But it was, again, before the 2015 case, before the 2021 case. And that was done, again, by the correct person with signing authority, and it was in compliance with Chapter 183, 54B, which means it was at most voidable. It's not void, and therefore Mrs. Coulsey wouldn't have the ability to challenge it. There were issues in her brief. I know she didn't mention an oral argument, that it was outside the PSA closing date. That's been decided by this court on the bowling case. She mentions we can't enforce the note because it's been more than 6 years since it's been accelerated, and again, that is something that's been decided by this case, this court in the Duplessis case. There is the UCC statute of limitations does not apply to foreclosures or to notes when trying to foreclose. Those issues just don't apply here. And if your honors,
What is your position on what is actually under appeal here? Because when I look at the assembly of the record, the order or judgment being appealed is the box that, this is not English. The order or judgment identified as being appealed is the judgment dated February 14th, 2023, which is a housing court judge's summary judgment decision. Do you believe that also encompasses a ruling on the motion to dismiss?
I don't, but the way that the summary judgment arguments and briefing went, even though the defenses and counterclaims had already been stricken, Mrs. COULSEY did still include those in her summary judgment opposition. So I wouldn't be opposed to those issues being decided to, because it was part of the briefing, it was part of judge's decision also.
Okay.
If there are no other questions, I would rest on my brief.
No, I see no questions. Thank you both very much for coming today and answering all of our questions. We appreciate it.
Thank you, Your Honor.
Okay. So I think we'll take a short break. Well, we have two more cases, and what we're going to do is take our morning recess now and come back and hear both of them. So we'll take a short recess. Thank you.
All rise. Court is now in session. Please be seated.
All right, so good morning. The next case is 2023-1352. I'm going to tell you right now, I'm going to have a difficult time pronouncing the names of the parties here, so forgive me, but it's DEEPAK Jular, I believe, versus NEETA Kumari. And please correct me when you take the podium.
Good morning. Thank you, Your Honors. My name is Soraya Sadeghi, and I represent the appellant NEETA Kumari, and this is my co-counsel, Jeffrey Pickering. We were trial counsel for Ms. Kumari, and we are here today on appeal. And the first issue that I would like to talk about is not my client's main issue or most important to her. Her most important issue were the children throughout this litigation. There were 9 motions filed throughout the course of the litigation because of the children. But the main appeal issue that I'd like to speak to the court about today is the marital home and the time lapse of the judgment. And I know that the court has reviewed our briefs, and the standing order, which is 1-06, was put in place for a reason, right? For public policy reasons. We have standing orders to issue judgments in cases. And in this case, it took a year and 1 month. And the court apologized at the trial and said about 5 to 6 months that she would issue a decision, and it was double that, which myself, my co-counsel, we would have never advised our client to stipulate to a fair market value of the value, and she would have not done that either. There was no way for us to possibly know that the court was going to violate its own rules and issue a judgment a year and 1 month later. On top of that, I would like to point out that civil cases, there's statutory interest, post and pre-judgment statutory interest. That was not accounted for in this case. There's no mechanism in the law, and the court could have easily considered this. Now,
Can I just pause you for one moment and ask about your 1-06 argument? Looking at that standing order in the preamble, which is at page 85 of your addendum, it says these time standards represent aspirational goals. And then it does, as you maintain in section 19, give a 90-day aspirational goal for entry of judgment or decree in a case of the trial length here. Do you have any authority for the proposition that this standing order gives a substantive right to a litigant?
I don't know if it gives a substantive right to a litigant, but I think that it would be a miscarriage of justice to allow, and really the trial was, if you look at the transcript, the trial was 2.5 days, and we were on strict time standards, but the first full day was split in half because the court tried to get the parties to settle and spent substantial time. So if you look at the time standards, 3 to 7 day trial, you get 90 days. It was a 2.5 day trial. I also point to the Obera versus Gorishi case that just came down not so long ago, where the court did remand. It was a year and 5 months from the judgment to refinance, and that case is almost identical to this, where it was, a year and 1 month. In terms of the marital home, it was really the main marital asset. It's not like in other cases that were cited in the appellee's brief that there was a business for the husband and the post-divorce judgment that the business increased solely due to the husband's work and contributions to the business. This was the main marital asset. It's not that wife got, a medical practice and the husband got the marital home. This was it. Also, this was the grandparents' home. The grandparents lived there. There was testimony to that. There was facts about that. And the children lived there. So in terms of the court awarding the marital home to the husband, we do see some bias here in this case. And the bias in this case is that the parties stipulated that they would each claim one of the twins for tax purposes. The court completely overlooked that, incorporated it into the judgment, and then later, in the subsequent part of the judgment, decides to say husband gets to claim both children. In the rationale, it says best interest of the children for the husband to do that. It's a conclusory statement. I don't see where it's in the best interest of the children.
The judge corrected that, though, right?
The judge corrected that. but it shows the bias. It shows the favoritism towards the husband. There's other examples of the favoritism that I will get into, but what I'd like to talk about next after the home is the debts of the parties. The pretrial order says that it's division of assets, but we know 208 Section 34, it's assets and liabilities. I don't know how one could just take a look at the marital estate, divide the home in the percentages in the way she does, and then just say everyone keeps their own debt. I don't think that's reasonable. I don't think that's what the law calls for, and it doesn't stand for. At the trial, there was substantial evidence of the monies that the grandfather, the maternal grandfather, gave to the parties and loaned the parties throughout their marriage. When we take a look at the statutory factors, we have to look at the contribution, and there should have been some discussion or findings about these debts. It was almost completely silent.
Well, I mean, I'm looking at Record Appendix Volume 1, page 175, finding 137. No credible evidence was offered to suggest that mother will have an obligation to reimburse her family for her remaining loans, and remaining is excluding the down payment on the house she has accumulated during the pendency of this action, and they are not treated as marital debt, promissory notes notwithstanding. So that's a credibility determination by the trial judge, right?
It is, but there's no real basis for that credibility determination.
Well, the judge saw the parties testify. Isn't that the usual basis for a credibility determination?
Yes, but she completely ignores all of the documentary evidence of the monies that were spent. She also ignores the fact that the husband concealed a safety deposit box, and then it was part of, safety deposit box, they have to be disclosed on financial statements. It wasn't. It came up at trial, and then the judgment is totally silent. There's no findings regarding the safety deposit box. There's no finding regarding my client's jewelry, her marital jewelry. This is Indian culture. It's very important, and it's very substantial. There was no dowry paid in this case. It was an arranged marriage, and I think that goes really to some implicit bias by the court, that the court really didn't even understand some of the issues that were before the court in terms of the dowry and the arranged marriage, even though there was substantial time spent on testimony in addressing those issues. The other issue about the marital home is that my client, which there was a credibility finding that she was credible, that she literally left with one suitcase, yet the contents of the home was not divided. It was just simply given to the husband. If you could imagine living 40 plus years, and then all of a sudden one day you are to leave the marital home and you can't go back into your home to find any of your personal belongings. There was testimony and findings that even photographs that were not children's photographs, not related to marriage, my client wanted, she can never get those back. She can't get anything. She can't, all of her personal belongings accumulation, and the court found that the wife had a value of approximately $44,000, and the husband had a value of about $5,000, yet there's no discussion or finding as to why the husband just gets to keep everything. And really, there's a lot of blanket best interest of the children, best interest of the children. Why is that the best interest of the children, to strip one parent of everything and one parent gets to keep the other thing? And I think that's why we have alimony support and child support for public policy reasons, is that one parent shouldn't be, living, for example, if it was an NBA player and he makes $10 million a year, and then the child is living in a Section 8 apartment, that wouldn't stand. So I don't know why this case is any different, that one parent gets everything and the other parent gets nothing, one suitcase, which the court found credible. I then want to turn your attention to the child support issue, which is a very big issue because, as we know, child support guidelines are based on various considerations, which includes the parents earning income and other evidence of ability to pay. That is the child support guidelines. And during the course of the litigation, my client was without employment due to no fault of her own. The court found that she was commensurate, her earning capacity at $60,000 was commensurate with her ability to earn, and found that credible, and that she engaged in a credible work search. I'd like to point out the calculations that the court found, page 89, mom's expenses. She didn't find that the $2,000 that she listed was really reasonable, but she found that mom's real expenses were $1,659, which is and a specific finding that was more than $500 than her current gross income. And father's income was her father's expenses was $1,475. She then bases the child support guideline on $1,154 of mom's gross income, dad's gross income of $2,312, and then orders my client to pay $298 per week on a gross income of $1,154, finding that her expenses of $1,659 is reasonable. That's just a simple math error.
So I need to slow you down for a moment. My understanding of the argument in your brief related to child support was that you maintained that it was inappropriate for the judge not to have retroactively reduced the amount of child support that your client was ordered to pay to reflect time periods during which she was unemployed. Is that what you're talking about now? Because it sounds like you're talking about something different.
I am talking about something different right now. Right now, I'm just talking
Raised
about...
in your brief?
This was not explicitly raised in the brief.
Okay, so we can really only address issues that are appealed and are briefed to us.
Okay, so that is an issue, that you cannot order child support payments when someone is not employed at the level that the court did, and she found
Is that something that you raised in the trial court? Is that a request that was made of the trial?
Yes, and in fact, it is stipulated, and it was an order of the court on February 2021, that the issue of retroactive child support was to be addressed at trial. And it's in the court's...
Where is that in your materials?
In my brief or in my...
In your appendix?
Well, it's part of the judgment, Your Honor. It's page...
Page 45?
It's page 7 of 61 of the judgment.
That would be page 61 of volume 1 of your record appendix.
I would have to check, Your Honor, but it is...
I don't see that there, but I can look again more carefully when I'm not on the bench.
It's definitely in the appellee's appendix as well. The other issue is about the Rule 59. I want to make one statement because it was raised in the appellee's brief that we did not file timely. That is incorrect. Rule 6 specifically states you have 10 days, and on the 10th day, if it falls on a Saturday or Sunday, which it did, it was a Sunday, then you have the next day to file. So we did file timely, and this is proper relief before the court. In terms of the children, was obviously a very big issue for my client, and it was an abuse of discretion and an error of the law to make findings that the father undermined the mother to the children, and then the court then reduced the parenting time for my client.
What do you mean by that? Are you talking about the fact that for one of the twin girls, there was a change from having 3 weekends of visitation to a change where for 2 of the 3, it was at the daughter's election? Is that what you mean by reduced parenting time?
Yes, and if you count out exactly the days and in the holidays and the days that we calculated down to the T, because these parties were into calculating hours and time, my client had reduced time. And the election of a child, I mean, we're really giving power to a 13-year-old girl who, there was testimony at the trial, is that this 13-year-old girl essentially controlled the entire family from the GAL. We're giving, full power, which is not the case law. The case law and the standard is really that a 13-year-old their opinion should be given some deference, but it should not be controlling. And I don't see how one could on one hand, say the dad is undermining the mother to the children. The dad is not agreeing to take the children to family therapy on his parenting time when he has the majority share, the lion's share of parenting time, and that somehow we're going to let now the 13-year-old child that's controlled by the father, that's being undermined, decide for the parenting time. It's not logical, and as the cases say, that I lost that case, so I will continue with the other argument that I have.
Actually, you can sum up. I didn't realize when I was looking at the.
At 13
yeah, because
seconds.
your time is up.
Thank you. Thank you, Your Honors. Thank you for having us.
Thank you for your argument.
Your Honors, Sandy Duran on behalf of DEEPAK, JOGLEKAR, who is the appellee in this matter. Good morning. I want to start with one point I made throughout my brief, and that is the issue of waiver, which pertains to a host of the issues that Mother's Counsel raised. Really, I think there are 4 issues that were waived in this court, and that pertains to the valuation of the home, which the parties stipulated to before trial, did not take any steps to change that stipulation, and which each party used in their proposals that they provided to the judge. So it's not surprising that the judge then relied on that valuation. In post-judgment motions, the mother sought to raise the issue of a change in valuation and submitted an affidavit containing a 1-sentence claim that she believed that the value changed. So, and I believe that that motion was untimely because it was issued in connection with the amended judgment, which rose under the judge's sua sponte 60A order. No motion was filed by the judge, by the mother, after the original judgment entered, and the only change that the judge made was on the tax exemptions, which she characterized as a clerical change. So I think those issues were waived. Another issue was waived, and Judge Hershfang raised it, and that is the retroactive child support. In that case, also, no claim was made in the proposals for this retroactive reduction for the period when mother was unemployed. That issue was reserved in pretrial proceedings, but in the final pretrial order which was issued, the judge at the time, it was a different judge, it was somewhat equivocal and simply said support, nothing more, nothing less, as being an issue. But then the case proceeded to trial on 4 separate issues, all of which the judge addressed, not surprisingly, on a prospective basis. That is, what parenting plan would be put in place, what support, what property division, and whatnot. So the issue of that retroactive support, I believe, was also raised. In her proposals, the mother did not ask for any retroactive support. She simply asked for a support order in her favor, consistent with her request for primary custody.
Did the parties submit proposed findings of fact and rulings of law in this case?
They did.
And to your knowledge, obviously I can read, so I can look also. Was there a proposed finding or ruling from the mother on this retroactivity issue?
No. And the proposals are included in volume 4 of the appendix.
The supplemental appendix?
The supplemental appendix, which I submitted. The other issues that are waived, another one also pertains to the home, and that is mother's complaint that the home should have been delayed in its disposition until the children went to college. again, not raised in any proposals. And even if it had been, I dare say that sort of disposition would not have been appropriate given the ages of the children at that time, then being 13 and a half years old. Now they're 16, but nevertheless, at the trial, they were 13 and a half years old. There's also the disposition of the house contents, which counsel raised just before, and that is also, I think, waived because again, I apologize for repeating myself, again, in the proposals, mother proposed each party retain the personal property in his or her possession at the time father was residing in the home, had been residing in the home since a temporary order ordering the mother to vacate the home earlier in the proceedings. So you have 4 substantive issues, I think, which were waived before this court and don't merit any further consideration. The other issues, I dare say, speak to the judge's broad discretion in terms of entering orders concerning property division and whatnot, and or error of law. And I don't think any are really raised by the mother in her brief.
Can I ask you a math question, which is not my strong suit, that's why I went to law school. Looking at the various allocations for the house, the value of the house, they don't seem to me, 1, to line up with each other, or 2, to be sort of easily understandable in light of other rulings made by the judge. Do you have a framework for understanding the judge's reasoning on the house division? In other words, I'm going to give the mother credit for the $122,000, and then if A, if B, if C, people get this much money.
I think my response would be that issue wasn't briefed, Your Honor, and I think the parties are bound by it at this juncture. I will say it may not be a model of clarity on the judge's part, but I'll leave it at that, if I may.
You would also say, I trust that it's within her broad discretion to make equitable disposition of
Yeah, I'm not trying to be flippant. I will confess thinking of taking some time and trying to sort of parse that out, but it wasn't an issue that I had to sort of, I wasn't trial counsel. I didn't have to drill down in responding to the blue brief, so I didn't, just to be perfectly candid with Your Honor. So other issues that were raised, again, really go to the broad discretion. Mother complained about my client's whether he should have been attributed with income based on her expert's testimony. The judge was not required to credit that expert. The judge found that my client worked as a teacher of economics or finance and so forth for some time, never worked as an economist, which is what the attribution theory was based on. I don't think that's an abuse of discretion, and she didn't credit it. And other points that Justice Hershfang raised about the credibility issue really carry the day here. And so at the end, what you really have here is more dissatisfaction than colorable arguments. Clearly, mother wanted a different result. Clearly, she wanted more time with her children and so forth. But when the judge was faced with these competing claims, she made a decision. She was the umpire. She made the call. And ultimately, no error, I think, is identified that Your Honors can rely and look to somehow turn this around. Your Honors and Judge Ulwick, the trial judge, are not required to sort of take out a stopwatch and figure out where these children spend time. But the judge heard significant evidence, including evidence from a guardian, of each party's shortcomings as parents.
The guardian ad litem.
The guardian ad litem, yes. Right. And the judge effectively said, I'm going to credit Dad as the primary custodian. I'm going to keep that intact, and I'm going to adopt largely what the parties had agreed in February of 2021 by stipulation. I'm going to largely follow the guardian ad litem's recommendation on the parenting plan, not to the letter, but certainly within approximating what was recommended. The judge did not follow the guardian ad litem across the board. That the guardian recommended that absent using a parenting coordinator, which wasn't apt here or wasn't agreed here, my client should get sole legal custody. The judge didn't order that. So the judge clearly made her own decision. She weighed all the evidence as she must, and she came down. You know, as they say, when you're presented with these sorts of proposals on custodial and parenting plans, you make a decision which is not perfect and undoubtedly will upset both parties. And I think that's what happened here. And ultimately, you know, this case comes down to an appropriate exercise of discretion and no basis for reversal. And unless your honors have any questions, I'll rest on my brief.
Additional? No. I see no further questions from the bench. I thank you both very much for your
All the
arguments.
best.
And we'll take the case under advisement. Okay, so now I'll call the last case on our list for today, which is case number 2024-0251, KOUTRAKOS versus HELEN LALLO.
Good morning, Honors. It's a privilege to be here. So the first and foremost issue in this case is whether or not the trial court erred in its statement and or application of the relevant standard for the finding of a constructive trust. Our position is that the trial court both misstated the standard as provided in the case of Matthew v. Roman Catholic Archbishop of Boston, and then also misapplied
Attorney
that both...
Alexakos, could you help me out, please, by just pulling the microphone a little closer? Thank you so much.
Of course, I apologize, Your Honor. Thank you.
And you can go a little slower, too.
Yes, Your Honor.
Okay, thank you.
So to reiterate, our position is that the trial court erred in both stating and applying the standard as provided in Matthew v. Roman Catholic Archbishop of Boston to the facts in this case, both as it found, and again, while I rest my brief on these points, we dispute certain very important material facts in that regard. But even assuming that the trial court had those facts correct, under that standard, in fact, the trial court erred, as the trial court failed to identify that under the Matthew standard, whether or not the donor's intent does not determine whether or not a constructive trust is found, Your Honor. The correct standard is, in fact, whether or not there was a confidential relationship between the parties. And as provided in the case of Scoville v. Matucci, which we rely on in our brief at length, a confidential relationship is when one party has trust in and relies on another party, and the other party is aware of that trust. And in this case, as in Scoville v. Matucci, there were actually two confidential relationships between the parent decedent relative to the oldest child in which the parent relied, as well as between the oldest child and the youngest child, or in this case children, who were aware of the parent's reliance on the oldest child relative to their stated intent to benefit the youngest child, or in this case children.
So when I look at Scoville, one of the things that jumps out to me about that case, that to my read distinguishes it from your case, is that in that case, the evidence was uniform that the parent wanted the house to go to this presumably, somehow disabled child, and told everyone that that was the intent, notwithstanding the fact that there was a deed or a will, I can't remember, to the oldest child. In your case, by comparison, the evidence, as I think the judge said, goes kind of every which way. Why is it that Scoville helps you here?
So our position is that while the particulars are not entirely consistent, as the trial court correctly noted, sometimes the decedent said that his oldest child, Mrs. Lalla, would sell it to my clients for $1, or she would just give it to my clients after his death. He consistently stated that the house was to benefit my clients and that they were always supposed to have a place to live there. And again, the record on Scoville is sparse. It's all of, I think the whole case is maybe 4 paragraphs. There's much more granular detail here. In fact, our brief notes that, in fact, it's unclear based on the record we have in Scoville of what the defendant Scoville, the oldest child, had in her conversations with the deceased parent, where we have obviously more information about that in the instant case.
We don't have those kinds of conversations here, do we, between Ms. LALLO and her father?
I would note that on the record, there was one conversation between the decedent parent and Scoville, which predated the deed and the will in Scoville. And so, analogous to the instant case, the defendant, Mrs. Matucci, in Scoville could have argued, and she may have argued, we don't know based on the record, or at least I don't know based on the record respectfully, she could have argued, oh, we had the conversation, but then my mom said to me that I wanted to have the house, analogous to this case. What mattered was that she made consistent statements of intent. And again, analogous to the point that if the intent of the donor doesn't determine whether it's constructive trust, the awareness of the trustee doesn't necessarily control either, as provided, I've had the case now at this point, but a trust will not fail for lack of a trustee. A trust can be found even absent the awareness of a trustee, forgive me. And to that point, I would also note that there's a case of Hatton v. Meade in which this trial court found, and this honorable court addressed a point, that the decedent alleged grantor of the constructive trust may have actually been intentionally misrepresenting his statements of intent, that he had no intention of the beneficiary of the putative constructive trust benefiting from his property, but based on his statements of intent, regardless of his actual intent, that a constructive trust had still arisen. And so even if the trial court didn't err in finding that he was making these misrepresentations with my clients, and even if he made no statement of intent to Mrs. LALLO, because he made these statements of intent that gave rise to a confidential relationship with my clients, then in fact a constructive trust still should rise under the Maffei standard analogous to
Just back
Scoville.
up and repeat that for me again. You said based on the statements made to your clients.
My clients, correct.
Which statements are you referring to?
As the trial court found,
Go ahead.
Mrs. KOUTRAKOS alleged, one of my 2 clients, that he made multiple statements to her of intent for her to benefit from the property. The trial court did not credit the statements. However, my other client, Mrs. Christina Gogan, also made statements which trial court did not discredit, in fact, one of which it did credit, that he had also made statements of intent for her to benefit from the property.
And was that before or after the deed was?
After the deed, Your Honor.
Okay.
And again, there were also separate conversations prior to the deed in which he made statements of intent, but those are more important relative to the conveyance, of course.
The challenge that I'm having in accepting your argument is that it seems to me that accepting your argument here requires us to ignore or to counter credibility findings made by the trial judge. And as you are, of course, aware, that's not the province of an appellate court. Those credibility findings are really almost exclusively the job of the trial court. How is it that we can do what you're asking us to do in light of that governing legal principle?
Yes, and I apologize for maybe not stressing this stuff in my briefs. The issue is that actually, even if this court did not discount the trial court's credibility issue, the credibility issues which we do raise in our brief, even if the trial court's factual findings stand, based on the Hatton v. Meade standard, even if the trial court didn't err in finding that the decedent was misrepresenting his intent to my clients, the fact that he made the statements and my clients relied on them itself gives rise to constructive trust because of their confidential relationship with him.
But why do the statements to your clients give rise to a constructive trust and the statements to Ms. LALLO, are we to discount those? I mean, she testified that he told her the house was hers.
Yes, Your Honor.
So that sounds like we're weighing some statements he made against other statements he made. And again, the weighing, not so much what we do here.
Of course. There are 2 points I'd like to make in that regard. Again, in the case of Hatton, that's distinguishable from this case in that it was the putative beneficiary of the putative constructive trust suing a state. There was no trustee. A trustee would have to be found upon the finding of one. I would argue that to the extent that Mrs. LALLO could claim that she had no awareness of the trust, the alleged intended trust, then nonetheless she could still be appointed constructive trustee as the holder of title to the property, given these statements. But also, of course, as the trial court found, there were conversations, there was communications between my clients and Mrs. LALLO almost immediately after the decedent's death, as evidenced at, I believe, page 124 of the record appendix, in which my clients expressed, referenced the decedent's statements to them and their reliance on that, and Mrs. Lallo did not dissuade them from that. In fact, seemed to accept that relationship by saying that she would convey the property to them pursuant to the decedent's wishes upon her confirmation that there were no liens on the property.
And how does her apparent acquiescence in those emails, and I'm viewing this obviously in your view, I'm not saying this is how it was, reflect on the intent of her dead father?
I would speak that I think that is important in two regards. First, it reflects, and I don't want to get off topic here, that in fact she had some awareness, even if there's no conversation between her and the decedent, that in fact these statements were made by the decedent to my clients, and she was aware of this relationship, from which, analogous to Scoville, the confidential relationship between the parent and my clients could be imputed to her, but also that creates a confidential relationship between her and them, as she was aware of their belief and continued to allow them to rely on that. She let them live in the house for 4 or 5 years, half a decade, charging them no rent, expressing no intention to sell the property out from them, and taking their claims for granted that in fact their father had said that they could continue to live in the house and that was for their benefit. I think this speaks to the existence of the trust and that she was acknowledging a confidential relationship existed. Not that they would necessarily use these legal terms, of course.
How has that become a knowing and confidential relationship? Just because Ms. Lallo is now, or there's some indication that she is aware of at least what your clients believe, whether they're right or wrong, but only what they believe.
Precisely, because a confidential relationship comes from, again, one party's trust in another party, and that party's awareness of the other party's reliance on their trust. In this case, my clients relied on Mrs. Lallo's acting as a constructive trustee, again, not that I use these terms, and she was aware of their reliance on her and never refuted that or pushed back on that once, up until she decided to sell the house in 2020, 2021, but several years after the father died.
Okay.
And to wit, because of my client's reliance on their father, and he was aware that they were relying on that, as at least one of my clients continued to live in the property, there was undoubtedly a confidential relationship between the decedent and my clients, and there was subsequently, at the very least, subsequently a confidential relationship between Mrs. Lallo and my clients, as she at the very least became aware of their reliance on their father, and then relied on her. And so there were two confidential relationships at the latest, even assuming a confidential relationship did not, for lack of a better term, sublimate from the father to Mrs. Lallo directly, which, again, our position is that it did.
Mm-hmm. Okay.
And I would like to draw attention, just for the sake of thoroughness, that again, Mrs. Lallo testified that he said he was going to deed the house to her, and that there was more to the conversation, but she could not recall what it was. So even under her own case theory, he may have very well explicitly stated that it was for their benefit, and she didn't recall that, respectfully.
Okay.
Are there any other immediate questions I can field for the court, or may I continue to conclude my train of thought respectfully?
That's all right. I don't have any further questions, but I'll check with the panel, and I don't see any questions for them either, so thank you very much for your argument.
Pleasure. Thank you, Dan. Thank you, Your Honors.
I was going to say good morning, but I think it's
You're
good
on the
afternoon.
cusp, so we can say
Very
good
close, very
afternoon.
close, and Happy
Okay.
New Year.
Over one.
If Your Honors, please, my name is Steve Abraham. I represent Helen Lallo, the appellee in this case. This case was tried by me in the Worcester Probate and Family Court over the period of 3 days, 3 consecutive days. There were 9 witnesses. 8 were called by the plaintiff, and I called Helen Lallo. 6 of those 8 witnesses were family members of the KOUTRAKOS family, and there were 2 lawyers, Attorney Turk and Attorney Tree. Because of the nature of this type of case, and because of the focus, I believe, on my brother's argument that there was a constructive trust, I'm going to focus on that today. One of the cases he relies on is the Maffei case, along with Scoville. And in Maffei, it makes it clear that a constructive trust is a flexible tool of equity designed to prevent unjust enrichment resulting from fraud, a violation of a fiduciary duty, a confidential relationship mistake, or other circumstances in which a recipient's acquisition of legal title to property amounts to unjust enrichment. The court heard these witnesses, saw these witnesses, observed these witnesses, observed how they testified and their reactions to questions and cross-examinations. And the result of their testimony caused the trial judge to confirm that there was no unjust enrichment to Helen Lallo. As a matter of fact, he even commented that Helen Lallo is the one who was possibly unjustly enriched. She lived in her father's house from 2004 until today. She
I
continues.
think you misspoke.
Yeah.
Yeah, I think you mean Ms. KOUTRAKOS.
Ms. KOUTRAKOS continues to live in that house from 2004 until today with John Anderson, the person who worked with her dad. She has never paid rent. She doesn't use her own money to pay any of the bills. She has stopped paying the insurance. She has stopped paying the taxes. And so I believe that her dad took pretty good care of her. The decedent prepared his will in 2008. One of the statements that one of the granddaughters said or talked about her grandfather's intentions was made in 2007. Fast forward to 2012 when the decedent called a different attorney, Attorney Turk, not Attorney Tree, who did the will. Attorney Turk prepared the deed, recorded it, told no one about it. He didn't tell Chrissy, he didn't tell Karen, and he didn't tell Helen until after the deed was recorded, some 30 days after the deed was recorded. Unlike when he prepared the will, he told Karen right away. My client, Helen Lallo, had no idea what was in his will, no idea that he prepared a deed for her benefit until he told her. The evidence is clear that he never discussed Karen or Chrissy or any of the other family members. The evidence is clear that the lawyer, Attorney Turk, received no instruction from the decedent about any limitations or contingencies with respect to the deed. It was a deed to Ms. Lallo for less than $100, and the judge determined that was a gift. No conditions asked. Was it unfair? Was it unconscionable? Did Helen Lallo coerce her dad into putting this deed in her name so that she could steal it from her half-sisters? Absolutely not. It was never brought to that court's attention. There was no evidence of that. As a matter of fact, unlike the Scoville case, where the decedent, mom in this case, trusted the grantee of the deed. The grantee of that deed was her confidant. Talked to her attorneys, talked to her doctors, talked to her bankers. The decedent in the Scoville case told the grantee, I want Valerie to get the property. I want Valerie to own this house. I want you to take care of Valerie. Told other family members. There is no dispute about that. In this case, nobody said anything. I know that we like to make it sound like there was conversation. There was maybe 3 lines of cryptic conversation that Judge German determined to be all over the place. After the deed was recorded, from 2012 to 2015, Karen KOUTRAKOS lived in that house. Chrissy never lived there. She hasn't been there forever. As a matter of fact, her testimony, you would think, would be helpful, but she said nothing about any of her dad's intentions or any thoughts about what Karen KOUTRAKOS could do with that house. When Dad died in 2015, Karen KOUTRAKOS, the plaintiff in this case, filed a voluntary statement in the Worcester Probate and Family Court within 30 days after he died. Before he died, she brought a lawyer to the house to try to convince Dad to transfer the house to her. All on the record. After he died, she filed a voluntary statement. No listing of any real estate on the voluntary statement, only personal properties. And when questioned about the assets in the estate, she said she sold all of the property. She did not distribute it to her sister like it said in the will, did not pay any of the claims that were filed in the Probate and Family Court, but kept all the money to herself. I believe that the judge looked at some of that testimony and made credibility determinations, made character determinations, and used that in making his decision. There was no abuse of discretion. He did what he is supposed to do. Take all of the facts, take all of the evidence, take all of the testimony, weigh it, and make a decision. That's what he did. From 2015 to 2021, Karen KOUTRAKOS lived in that house. She was not kicked out, like in the Scoville case, where the grantee, within 30 days, had her sister move out of the house. 5 years, 6 years she lived in that house, until my client received a notice from the insurance company saying that, we got to look at this piece of property. We get issues with this property. My client then notified Karen, and Karen became a little upset. You need to give this house to me. 6 years had passed, not a word. Now, all of a sudden, she is claiming that she was the beneficiary or should be the rightful owner with her sister to this house.
Well, there was some communication. Wasn't there some communication?
Your
Wasn't there some communication between your client's son and a member of the
Chrissy,
family? Yeah.
the other sister.
Right.
There were emails between them, and neither one of them could make out what the situation was. I think the trial judge actually alluded to some of the son's statements saying it's all over the place.
Well, his eyes would glaze over thinking about it.
No, that was one of the comments.
But there was a communication, let's put it that way.
Between the son,
Right.
Helen's son, and Karen's sister, Chrissy.
Right.
Correct. There was no communication about the house between Karen and Helen, although they did communicate
Well,
about
except
their
for the
dad.
fact the son indicated that he was going to convey the contents of the
There
conversation.
was no conversation of the like.
Yeah,
Correct. And then in 2021 is when the litigation started. And again, as I indicated earlier, Karen KOUTRAKOS continues to live in that house, does not pay any of the bills, does not pay the water and the sewer, the real estate taxes, or the insurance. And I believe that the judge made a decision based upon what he heard in court, what the testimony was, what the lawyers stated under oath, and listened to my client, who was not looking for a property, was not looking to do anything. She's 78 years old right now. And it became a burden for her in 2021, when she received this notice. I would submit to your honors that the decision should stay, should not be reversed, and that the judgment should be affirmed. Thank you very much.
Any further questions? All right. Thank you very much. There's no questions from the panel. Thank you for your arguments. We'll take the case under advisement. That's our last case for this morning, so the court will stand in recess. Thank you.